Thank you, Cem abi. Tonight we will be talking about ICOs and IPs and their intersection with blockchain technology and also crowdfunding in terms of ICOs. I'm Batuhan Demirtaş from Maltepe University and Hasan Ömür from Tevatol Legal. I will start with ICOs and crowdfunding. The reason why crowdfunding is necessary is because entrepreneurs often don't have enough money to fund their ideas. People with great ideas sometimes don't have the cash they need, and that's where crowdfunding comes in. The government all around the world has made rules to allow people to get funding for their ideas and keep up with all the new technology. The main point is that when big or small investors join a potential lucrative project, entrepreneurs get the money they really need. And moreover, crowdfunding is when a bunch of people, even with a little bit of money, come together to raise a lot of money. So crowdfunding is a really effective way for anyone actually, even with just a small amount of money, to get involved in the financial system, which is actually very desired. An initial coin offering, also known as shortly ICOs, is basically when crypto assets are introduced to the public or sometimes a little restricted participants. These assets can be offered at different stages, like during the project phase, development, or after even it's done. Once they are out there, you can buy, sell, or even keep them on crypto asset transaction platforms such as Binance and etc., or keep in your hard, cold, or hot wallets. ICOs are becoming more popular for a few reasons. One is that it's easy, it's actually reliable, and also cheap to use technology for generating, storing, transferring, or investing in digital currencies or assets. Plus, with economic crisis and lack of trust in institutions, people are turning to technology for solutions. People are looking for new ways. ICOs are now a more convenient, faster, cost-effective way to crowdfunding compared to traditional financial services. There are basically four main types of crowdfunding. The first one is reward-based, second is donation-based, equity-based, and debt-based. And in each type, the relationship and structure between the parties involved tends to change. Every one of them is little different. Crowdfunding can be done in different ways and divided into different categories depending on what they offer in exchange for the money. There are also four main types of models: donation, reward, lending, and equity models. In the first two types, there is no formal partnership or debt between the funders and receivers. Giving shares or debt to the funders isn't always required in crowdfunding, and sometimes these activities are also connected to social responsibility projects. In donation-based crowdfunding, people give money to a project without actually expecting anything in return. In reward-based crowdfunding, investors is not the right word for this one. People get a reward back, which could be something valuable or just sentimental. In both types of crowdfunding, there is no official partnership or creditor relationship between the people involved. In debt or equity crowdfunding, the folks who provide funds basically become investors, and they are typically focused on making some money. It's their motivation behind the crowdfunding. They either become partners or creditors to the companies or project they fund in return for the money they put in. In debt-based crowdfunding, the money collected from investors is basically a loan. The entrepreneurs who receive the funds have to pay back the investors along with some extra money with interest. I mean, the investors in this kind of crowdfunding are kind of like people who lend money hoping to make a profit by getting their money back with some interest. It's kind of like how government bonds actually work. When you think about that relationship between the investor and the fund company, and the fact that the main goal for the investor is to make money, you could say that the bond between investors and the funded company isn't as strong as with equity-based crowdfunding. What do I mean by that? In equity-based crowdfunding, instead of looking for extra cash loan for the funded company, we are on the hunt for partners to join the company. With this kind of crowdfunding, the capital provider becomes a partner in the company, receives a share of the company. Investors who chip in funds and become partners through equity-based crowdfunding may get a piece of the profits from the partnerships, as outlined and depending on the agreements between the parties. People who want to raise money for their ideas and projects are typically the first group involved in crowdfunding activities. There are three legs of crowdfunding. There are three participants of crowdfunding. First one is people with their ideas, entrepreneurs without enough capital to bring their ideas to life, and who are on the lookout for funding. These entrepreneurs usually go for a crowdfunding platform to get funds for their ideas and projects instead of doing it themselves because they are unable to or unwilling to. Investors who want to support ideas and projects that need more money can find out about them through these platforms and provide financial help. Crowdfunding platforms are basically acting as a middleman in this whole process. The last and probably, excuse me, the last and probably the most important part of crowdfunding is made up of investors who want to fund entrepreneurs' ideas and projects. These investors play a crucial role by providing the necessary funding. They can become partners in the fund company, creditors to the company, or simply act as donors or supporters without expecting anything in return. The role of the investor varies depending on the type of crowdfunding. In equity-based crowdfunding, as I said, investors become partners, while in debt-based companies, they become creditors. So basically, in crowdfunding, you got the idea or project that needs money, platforms that help connect investors with these projects, and people who want to give money to these projects. And it's important to remember that there are legal relationships involved within the platforms, the project creditors, and the fund providers. So they have to follow the rules. Roberto, your mic is on, by the way.
Sorry.
No problem. Thank you, Sabrin. Crowdfunding in Turkey. In Turkey, crowdfunding is mostly regulated by capital markets law. To crowdfund, you have to go through licensed intermediaries known as crowdfunding platforms. The process of getting licensed and setting up these platforms is actually quite tough and demanding. They have to register with the capital markets boards of Turkey and consequently for many boards such as investment board, audition boards, and etc. All of these boards require at least 5 people to become member, and there are some serious conditions requirements for those people. Additionally, there are strict provisions in capital markets law that require extra requirements for setting up crowdfunding platforms. These include things like having a minimum amount of capital, restrictions on who can be a shareholder. So basically, as a normal people, meaning that you don't have any professional experience or educational background on crowdfunding, you can't just go as a normal citizen and say, I want to establish a crowdfunding platform. There are some strict requirements. Also, not everyone can become a partner or shareholder to that crowdfunding platforms. And minimum educational and professional experience for board members and investors are actually sought. It's totally not allowed, and you could get in very big trouble if you try to do crowdfunding without permission. Actually, it is considered like you are doing some unlicensed, unauthorized market stuff, capital markets stuff. If you get caught, you could actually end up in jail for 2 to 5 years. In addition to having to pay a huge fine. Also, it is important to mention that just because the crowdfunding activity happens outside of Turkey doesn't mean that Turkey's laws don't apply to you. According to the crowdfunding communique from the Capital Markets Board, if a crowdfunding activity is promoted or enabled for Turkish citizens or legal entities, then both the crowdfunding itself and the people managing it could be held accountable under Turkish law. So it is very important for crowdfunding companies and their managers to be cautious about how they advertise and promote their activities. Sabri, we can move on to the next slide. So let's introduce ICOs. There are some new ways to raise funds that have popped up lately using blockchain technology. One of them is called ICOs, where you can sell blockchain-based tokens or coins in exchange for crypto assets or regular money. These tokens can be used for various things like assessing a product or a service, representing assets, or showing ownership in a project. Plus, a lot of people who buy these tokens are looking to make a profit by selling them on a secondary market. The first token sale happened in July 2013 by MasterCard, and then Ethereum and a few others followed in the following years. ICOs became more popular after the DAO's token sale in 2016, which was actually an unfortunate event. In this ICO, the crowdfunding ICO raised about $150 million. But it was in 2017 when a lot of money starts being raised through ICOs. By the end of 2018, ICOs had raised around $24 billion. Despite facing regulatory change challenges, uncertainties, the number and size of the offering kept growing. Okay, what are ICOs and why should we care? Well, ICOs are basically a way for business to get money by giving out digital tokens or coins in exchange for real or virtual currency. These tokens give investors a chance to get in to the action, make some money, and maybe even sell their tokens later on for profit. So let's say that, let's give you an example. An amusement park that wants to get built, the managers or the builders of that amusement park could issue some crypto assets such as tokens to people who want to invest in it. Then those token holders can use these tokens to get into the park or trade them for some cash. Businesses make some tokens and sell them to investors once they registered them on the blockchain, unlike regular banking system where money goes to a main server, then it's distributed. The blockchain is decentralized. That logs transaction on a bunch of computers. This lets people move crypto assets between digital wallets, giving a fresh way to create and trade assets without centralized intermediaries. The blockchain, which is like a record, allows anyone on the network to check and keep an eye on the movement of assets across different networks. When a computer joins the networks, it gets a copy of the blockchain and etc. You all know that. The reason for big rise in ICOs is because they have some great benefits for both investors and issuers. One big advantage for investors is the chance to make a lot of money. With ICOs, you can invest in a project right from the start without having to invest a lot of money. So even regular people without not with any spendable capital can make very big profits. ICOs are a great way for, as I said, everyday people and for anyone. Normally, if you want to invest in a company at initial public offering, you'd have to pay extra because the big shot venture capitalists already took the best deals. But with ICOs, your chances are higher because everyone gets a considerable fair shot from day one, since all the info about the company is out there for anyone to see. ICOs have a lot of perks for companies. Founders get to keep all the money raised, unlike with venture capitalism. Plus, ICOs don't have to deal with pricey paperwork generally. So more companies can join in. And the best part, they are also great way to fund projects that might not interest venture capitalists. Because blockchain is global and doesn't care about borders, investors from all over the world can totally get in on it using blockchain and crypto. Since blockchain keeps super secure records, investors can trust that their money is being used in the right way. And finally, ICOs make crowdfunding a breeze. Crowdfunding can be a hassle due to all the regulations in different countries, and these regulations sometimes critically vary between each other. You usually need permission from multiple governmental bodies to start a crowdfunding project. Plus, there is often an intermediary who handles the funds, so ICOs generally disable these intermediaries. This new technology can change the way people get money for things, but it has some problems right now. Some bad people, ill-intended people, trick others into giving them money by giving big rewards. Sometimes ill-intended people try to trick others into giving them money by actually lying about the project or the investment. They tend to lie a lot and show the project very valuable, and when lots of people start buying them, these people sell their own investment and make money. It's like they're pumping the project, prices go boom, then they sell all their assets and people get scared, they sell all their assets and lose money. But then they stop lying about investments, or they just stop working on the project, so the project becomes trash. If someone gives their money to buy tokens and something bad happens, like being tricked or having their money stolen, it's really difficult to get the money back because ICOs are made in a way that makes it hard for government officials to catch the perpetrators, to find where the money went. When people trade things in other countries or illegally without telling the investors, it becomes even more risky. For example, companies from other countries can sell tokens in the United States and get money without following the rules of US regulators. This makes it hard for SEC to punish any unlawful behavior by the company. Even if they find the thing being traded, the government officials might have trouble stopping or securing it because it's locked with a special code called private key. Because of the unfortunate things happening with ICOs, many jurisdictions now looking closely at them and trying to make rules for how they can be done. They're trying to regulate those. Also, since there are no established rules set by the governments so far, in some countries, United States, the government has specific laws for ICOs, but not in many countries. And for example, in United States, they have a test called Howey test to decide if a digital asset being offered is a security. If the offered crypto asset is a security, then the ICO has to follow even more rules and get permission from the government before they can even do it. If they don't get the permission or go without the permission, they could get in trouble and face some serious punishments. The legal status of ICOs depend on what kind of crypto asset is being offered and what it is used for. So it is important to look at the white paper, which explains the purpose of the ICO and what the crypto asset is for, what can it be used for. ICOs are like online events where people can buy and sell special coins called crypto assets. And these coins are generally kept in virtual worlds, which means they don't exist in a physical place like a bank. Because of this, ICOs can happen anywhere in the world, and anyone from any country can join in. But because of different laws in each country, sometimes it can be quite challenging to solve problems or disagreements that might arise during an ICO. What am I missing? Okay, depending on what the crypto asset offered can do and how it's used, it might be called different names, like initial coin offerings, it's for coins, initial exchange offerings, security token offerings, and equity token offerings or fund token offerings. They are almost the same, varying on the offered crypto asset. Before deciding what kind of name it should have, it's important to look closely at what the crypto asset can do. and what it is. In an ICO, the rules and laws for ICOs can be different depending on what the token can do. Things like if people are considered buyers or investors, the order and number of rules that apply, and who oversees, who has the jurisdiction, the authority to control that, it may seriously change. And traditional crowdfunding and ICOs are very different, actually. They are both used by people who don't have enough money for projects, but there are four main ways people can raise money through crowdfunding, as I mentioned earlier. In normal crowdfunding, people give money to a project and get a reward like product or service in return. But in ICOs, people give money and get digital assets or crypto assets and access to more things even in return. Traditional crowdfunding has rules depending on the website and the country, while ICOs are starting to have rules too. But both types of crowdfunding want to make sure people are safe and everything is clear. Traditional crowdfunding appeals to a lot of different people who want to support all kinds of projects. And ICO crowdfunding is more preferable for people who are really interested in blockchain technology. Traditional crowdfunding is often used for creative projects or small businesses, while ICOs are mostly for blockchain projects and companies that deal with crypto assets and blockchain technology. Usually when people raise money online, they can get the money right away in the form of regular money. But with ICOs, they raise money using called crypto assets. This is different because it allows people from all over the world to join in and give money without having to worry about intermediary banking, converting your fiat currency to another Turkish lira to dollar to euro, and etc. It gets rid of such problems. However, something important to think about is that crypto assets are very volatile. They can change in value very quickly, unlike regular money. When people invest in a new crypto asset, the value of that crypto currency can go very high or down. This is different from regular ways people give money to support a project. Also, ICOs have some technical risks that people need to understand, like how to use digital wallets and smart contracts. Moreover, ICOs can have big problems with how they work. For instance, there was a really well-known ICO called the DAO, and the DAO hack that had a mistake in its computer program, smart contract. This mistake led some ill-intended people to take money that they weren't supposed to have. The program that controlled the DAO had a problem that allowed the hacker to take advantage of it. The hacker used the trick which was possible because of the mistake in the program code, and the attack worked. And the hacker took so much money from the DAO. They kept doing this over and over again before the program could update how much money it had. By doing this, the hacker was able to take more than 3.6 million Ether, which was worth about $50 million at that time. That's it from me. Thank you for listening. Now I will let Asena take over.
Hi, everyone. Let's continue with the legal frameworks governing crowdfunding and ICOs. So let's talk about it a bit. When people use crowdfunding to get money instead of going to a bank, it can be risky, as Batuhan mentioned, for a couple of times. So this means that lawmakers need to think about how to make rules to keep people safe when they use crowdfunding. Sorry for my messages. Okay. Many countries are trying to figure out how to make crowdfunding fair and safe. So they have come up with two main ways to do this. So making laws to control crowdfunding or following some basic rules as they have. So they also have different ways to control crowdfunding for money and crowdfunding for social causes. So some countries think crowdfunding for money should have special rules, while others think it should follow the same rules as other ways of getting money. So some places even include a type of crowdfunding called, we mentioned a lot, ICO, in their existing laws about money and investments. Let's take a look about United States and then talk about SEC afterwards. So in 2012, the US introduced regulations to facilitate online funding for small businesses. So these rules were expanded in 2015 I guess, established guidelines for selling company shares. They set limits on individual investments and outlined platform requirements. So the focus was on fostering a conducive environment for emerging businesses to access capitals. So recognizing concerns about control, the US government is now taking steps to tighten the regulations surrounding ICOs. So viewing the sale of coins as analogous to selling stocks, the SEC may impose specific regulations and require individuals to seek permission from them. So this move aims to ensure a more rigorous framework and monitoring mechanisms for managing digital currency transactions. So both the Commodity Futures Trading Commission, we would call them CFTC, and the SEC share a common perspective on ICOs. So they're emphasizing security of the intentions and plans of the entities behind them. So the CFTC, while monitoring ICOs within its jurisdiction, allows compliant projects with well-defined plans and transparent information to continue their operations. So additionally, the CFTC expresses heightened concerns about fraudulent activities in the virtual currency space, so irrespective of whether they involve borrowing or trading with borrowed funds. Let's talk about SEC's regularity approach. So they are warning people that investing in crypto assets is different from other investments like stocks or money in the bank. So this is because if something goes wrong, like someone's stealing the money or a problem, or there is a problem with the technology, there is no insurance to protect the investors. So on the SEC's official website, there is information about ICOs. ICOs can be kind of an investment, and the SEC is in charge of making sure that investments things follow the rules. So they have to follow the rules as well. So sometimes ICOs need to be registered with the SEC. The things you get from ICOs can be called different names, but just saying it's a utility token doesn't mean it's not an investment. So the SEC says that ICOs can be risky and some of them might be scams or considered as securities as well. There was this case with the Telegram group versus SEC. So in 2019, the SEC accused Telegram Group of improperly raising over 1.6 or $7 billion by selling grams. Grams is like a special kind of digital currency for their Telegram open network. Telegram allegedly violated rules by not following proper procedures and providing insufficient information to investors. So the company promoted grams as a lucrative investment, claiming it would appreciate in value and be integrated into their messaging app. But at the time, grams couldn't be used for purchases. So SEC sought sanctions against Telegram, including substantial fine and the return of a significant portion of the funds raised. There is another report. It's called the DAO incident. So the DAO is a special group that used computer technology to do things without a leader. So they ask people for money by giving them special coins, which is called DAO tokens. But some people stole a lot of money. So the government looked into what happened and decided that these DAO tokens were like special papers that need to follow certain rules. So the SEC reports talk about how the DAO sold digital tokens in exchange for things like digital money. So it says that this kind of selling can be regulated by the government to protect people who are buying those tokens. So the report explains that the rules depend on things like if people expect to make money from the tokens and if there is someone helping to make that money happen. It is important for people who sell tokens to follow the rules so that investors are protected and the market is fair. There is another case between SEC and Kick Interactive. So the SEC accused Kick of violating regulations by not registering their offering and failing to provide necessary information to investors before selling their KIN tokens. So Kick raised substantial funds without monitoring the source of the money and portrayed KIN token as a profitable investment without assessing buyers' intentions. So the SEC is taking action to ensure compliance with investment regulations, seeking to return unlawfully obtained funds and impose a penalty. So the case underscores the importance of transparency and registration in selling digital coins. And in 2020, the court ruled that Kick must notify the SEC before any further digital coin transactions and must adhere to investment registration rules. And they also had to pay $5 million fine as a penalty. So yeah, not a great start for them. Let's talk about the European Union and MiCA. In 2015, the European Union started regulating crowdfunding, prompting member states to create equity-based crowdfunding laws, while charity crowdfunding followed existing regulations. The Gavison found diverse regulations in European countries, covering licensing, fundraising limits, and investor eligibility. So in 2018, the European Commission proposed regulations for uniform crowdfunding operations. Some countries like Finland, Lithuania, they have specific laws for loan and investment crowdfunding. For example, Australia regulates crowd-sourced funding, excluding charity. ESMA highlighted challenges for fintech companies proposing certain tokens be regulated as financial instruments. So crowdfunding isn't a financial instrument under MiFID II, and Malta and Switzerland have specific rules favoring blockchain and ICOs in some European countries. Let's talk about the markets as well. So the European Union's markets in crypto asset regulation, which I referred to as MiCA before, aims to provide clarity and legal certainty for crypto asset investors. It covers utility and e-money tokens, setting guidelines for their issuance and trading. The MiCA mandates comprehensive white papers for ICOs, emphasizing transparency, investor protection, and issuer integrity. So compliance requires regular reporting, auditing, strong governance, risk control, and etiquette funds. So the regulation addresses anti-money laundering and allows cross-border operations within the European Union. Non-compliance may lead to penalties. So MiCA seeks to encourage competition and innovation while ensuring investor safety and market fairness. In 2017, China banned ICOs due to the concerns of fraud and illegal fundraising. So this ban included shutting down ICO platforms and requiring organizations to refund investors. So the People's Bank of China cited the need to protect the financial market and investors, as well as prevent money laundering and fraudulent activities. So the ban had a significant impact on global crypto asset markets, causing a decline in the value of digital currencies. So this ban is part of China's larger effort to regulate crypto assets and prioritize financial stability to them. In Singapore, if business owners can't get funding from banks, they might try crowdfunding platforms instead. So they offer shares or debt to potential funders in exchange for their investments, and sometimes people lend money directly. So these arrangements are called securities-based because they involve giving out securities to funders. Before, promissory notes were excluded from this definition, but now they are also included. So despite some challenges with exemptions, the alternative finance market in Singapore is growing because of clearer regulations. So the MES is also willing to make it easier for securities-based arrangements. If crowdfunding platforms follow MES rules, there is potential for more growth in the alternative finance market. So the MES plans to give licenses to digital full banks and digital wholesale banks, which are separated from the digital banks already established by Singapore banking groups. Okay, can we move forward with the importance of qualification of offered crypto assets? We already have a paper on, it's called Crypto Conundrum, Navigating the Maze of Assets and Regulations Across Borders. So I would recommend, if you want more detail, you can see our paper on that. Maybe Mr. Jem can share it below on the chat. If possible. So let's continue. There are three main types of digital tokens in the world of crypto assets. So currency tokens are used for purchasing goods and are created by blockchain platforms. Their value is determined by the platform and they fall under banking law regulations. Utility tokens function as coupons that can be used to buy goods or services at a discounted price. They are considered the safest option legally, I would recommend, as long as they are not deemed securities. So security tokens, which are a problem for everyone, represent investments and are backed by assets. So they are regulated as securities and offer liquidity in the market. If a token is considered a security, it must be authorized by the government. And we talked about a lot of SEC regulations, which security tokens would fall under that. We can continue. So let's talk about the rights associated to an offered crypto asset. So ICO tokens can be divided into four main types of rights. They have usage rights, participation rights, profit rights, and ownership rights. So these rights can overlap, meaning a token can provide the holder with the ability to use a blockchain system, participate in its governance, and potentially receive dividends. So examples of these rights include the ability to use decentralized networks for various purposes, voting on content and governance proposals, receiving a portion of profits, and owning tokens that represent assets like gold or digital kittens. Okay, a security token can be created during an ICO and does not have to be associated with a company. However, a company can be established to manage the ICO if desired. It is also possible to create tools or assets for trading the crypto asset without the need for a company. So if the token gives ownership rights or incorporates an exchangeable instrument, it may be considered a security token. So in the United States, determining tokens and their ICOs are as securities involves meeting the requirements of the Hui test set by the SEC, as also Batuhan mentioned this. So if a token meets certain criteria, it is classified as a security token, and a team conducting the ICO must register it with the SEC. So individuals facilitating the buying and selling of these tokens also may need a SEC license. Okay, let's talk about the European Union's approach. And there is this case which is called S-Coin. So in 2017, Estonia considered creating its own digital currency. It is called S-Coin. So the idea was introduced by the head of Estonia's e-residency program, which allows people from other countries to start business in Estonia online. So the goal is to improve the program by using S-Coin as a token within the program. So the proposal also include involving the global community in S-Coin's development and potentially conducting an ICO to fund it. However, the proposal faced a lot of criticism and regulatory challenges, particularly from the European Central Bank, so which expressed concerns about the impact on the Eurozone. As a result, Estonia has not yet proceeded with its S-Coin plans, but it remains focused on blockchain technology and digital initiatives. Okay, so I think, yes, if you have any questions, maybe receive them now. Afterwards, we can move forward with the IP, our next topic. I guess we can move on and take the questions at the end.
I think we can continue.
Okay, I'm moving on. All right. Sabine, thank you. Our next topic, it's exploring the intersection of intellectual property and blockchain. Next slide, please. Thank you. Okay, let's talk about blockchain. We all know what blockchain is, but I will just make a summarize for it. A hybrid blockchain combines features of public and private blockchains. So public blockchains are open and decentralized, sorry, allowing for anonymity, while private blockchains are exclusive with centralized control. Consortium blockchains involve multiple organizations collaborating on a decentralized network. So in 1991, Stuart Haber and Scott Stornetta conceptualized blockchain technology, a decentralized, unalterable digital ledger, storing information in blocks. Businesses utilize blockchain for secure and transparent transaction and asset tracking. Each transaction is stored in blocks and added to nodes upon validation, creating a distributed ledger accessible to all network participants and enhancing security. The blockchain offers a secure, reliable database without third-party involvement, ensuring transparency and promoting accountability by recording all transactions. It facilitates a quick and efficient automated transactions with consensus among all parties for accuracy. Let's talk about IP, and then we will see how those interact. Okay. Intellectual property, I will refer to intellectual property as IP and intellectual property rights as IPRs from now on. So IP encompasses intangible human creations like inventions, artistic works, and logos. So creators are granted legal rights, including patents, copyrights, and trademarks to safeguard their intellectual creations for a designated period. In the digital era, IP protection is complex, but blockchain technology offers many potential solutions to it. The blockchain has a capacity to streamline copyright ownership, diminish piracy, and establish a fair digital property market. Additionally, it can facilitate compensation for creators through crypto asset payments and smart contracts. Overcoming specific challenges could lead to revolutionary transformation in the IP and copyright industry. Technology has changed, as we all know, pretty much everything in human life, even the law. So the law keeps up with technology and adjusts to it, which is super important for society's progress. So throughout the history, people's smarts have led to the creation of tech and ideas that really impact our social lives as well. So that's why we started protecting and supporting these creations. Nowadays, we have laws to protect the rights and hard work of individuals in science, literature, art, and any kind of art. So copyright and industrial property rights are given to encourage and safeguard creative things, but not everything can or should be protected because that would limit other people's freedoms. So we have rules to decide which works get copyright or intellectual property rights. Next slide, please. Where does blockchain and intellectual property meet? So the relation between blockchain and IPRs, intellectual property rights, is a win-win. So blockchain can help make the IPR's system more effective by acting as a tech-based registry. So this allows IP owners to securely store proof of ownership and get paid royalties. So it also streamlines the registration process for new IP and supports regulatory organizations with limited resources. Plus, it provides concrete evidence of copyright ownership, making it easier for creators to keep tabs on usage and prevent infringements. Using blockchain technology can greatly benefit global IP offices in keeping track of IP registrations by protecting the qualities of blockchain like resilience, trustworthiness, immutability, productivity, and safety. So IPRs play a crucial role here. Blockchain technology also has a potential to address the limitations and challenges faced by governments and agencies in safeguarding individual rights and fighting copyright piracy. Let's take a look on the applications of IP. And currently, local government agencies regulate IPRs, facing challenges in transparency, piracy, and fair compensation. So blockchain technology emerged as a solution by providing a simple way to verify the originality and existence of products, aiding law enforcement in identifying counterfeit goods. So in blockchain technology-centric landscape, IPR becomes crucial, with organizations leveraging blockchain for securing patents and managing various IP aspects such as applications, licensing, smart contracts, and record keeping. Blockchain ensures reliable, verifiable, and I would say traceable, accountable records, eliminating synchronization errors common in manual methods. So its features including immutability, security, as I mentioned, they have the potential to significantly transform the landscape of an IP. Blockchain technology has the potential to streamline and accelerate the registration process for IPRs, including trademarks, designs, and patents. So the current registration procedures are often time-consuming, and they are, I would say, very high costly, providing limited protection confined to individual countries. So blockchain has the capacity to enhance efficiency by expediting and reducing the cost of registration, and it could evaluate the uniqueness and inventiveness of intellectual works. Moreover, blockchain can play a role in contract management, ensuring fair and timely compensation for right holders directly, without intermediary involvement of any third parties. So it has the additional benefit of certifying product authenticity for consumers and preventing inadvertent infringement of digital resources. While governments and IP registries explore blockchain implementation, challenges such as defining governing laws, ensuring data security, and establishing reliable rules for smart contracts, they still need resolution. We can talk about smart contracts and IP as well. We actually have a detailed paper on this. So I would also name it. In blockchain, we trust the legal paradigm of smart contracts across borders. Maybe Mr. Jem can also share that one and you guys can have a look. So I will summarize it here and mention smart contracts for IP. So a smart contract is a computer program that automatically carries out actions based on predefined terms agreed upon by parties. So it is stored in blockchain, making transactions traceable and irreversible. So smart contracts can simplify the process of purchasing patents and can be integrated to IPRs to protect and manage ideas and inventions. So they can ensure compensation for IP creators, track ownership, manage royalties, and etc. So consumers need to understand the rights granted under a smart contract, especially in relation to NFTs. We will also talk about NFTs later on during this presentation. Blockchain can be used as a confidential platform to verify the ownership of IP. So unlike patents, which can be applied for at a patent office, copyrights require the creator to prove ownership. In the age of the internet, it is easy for anyone to download and use content freely as they wish. The blockchain acts as a tool to authenticate and timestamp the digital assets, allowing IP owners to store a secure digital certificate as a proof of ownership. This helps differentiate between counterfeit and genuine products by revealing the true owners of the IP. So in today's digital world, having a system like blockchain is important. It's very important for providing evidence of IP ownership. Enforcing IPRs is vital, but counterfeiting remains a significant challenge, unfortunately. So limited resources for law enforcement, especially customs officers, hinder effective verification. So blockchain provides a reliable instant verification record for both authorities and users. By storing ownership, license, and key information on blockchains, the entire supply chain can swiftly confirm product and its authenticity. Blockchain enhances IPR enforcement by addressing counterfeit items, offering data storage for brands, products, and services, instilling confidence in stakeholders. So inventors can also, creators can also leverage blockchain to showcase and license their inventions. Let's talk about some categories of IPs, such as trademark. Can you move on, Sabine, please? Oh no. Did you move? No, can you go back? Okay. Yes, well, okay. Maybe we didn't put it on. Okay, I will continue. So some of the intellectual property categories I would like to talk is trademark, patents, and trade secrets. So let's talk about them. So trademark registration, often required by many jurisdictions, they grant legal rights under the law. Blockchain technology offers a streamlined registration process, reducing the workload for trademark owners and offices. It facilitates tracking and proof of registered trademarks, notifying authorities swiftly. So blockchain records provide solid proof of use, simplifying information sharing and access. The technology can also lead to concise trademark descriptions. Concerns about data privacy can be addressed through the latest blockchain versions, combining public and private elements or allowing optional data sharing. While initial setup may require effort, leveraging blockchain can save time, money, and resources for trademark owners in the long term. Blockchain technology also attracts substantial patent filings, with China surpassing the US. Obtaining blockchain patents is challenging due to proving uniqueness and navigating complex, costly processes with verifying laws across many jurisdictions. So while permissioned blockchains for product verification align with regulations, securing patent necessities, differentiation, and avoiding overly abstract ideas. Concerns about patent disputes drive efforts for industry standards and fair licensing terms. Some developers skip patents due to cost and time constraints, preferring confidentiality. So, however, registered patents may be vital for investor attraction. Some developers adopt a mixed strategy, applying for patents and later licensing under open source terms or participating in cross-licensing patent pools. Blockchain technology is well suited for protecting trade secrets. due to its ability to encrypt and securely store information. This is particularly important now with the introduction of new laws in the US and the European Union. Blockchain can help prove the confidentiality of trade secrets by recording and tracking access to them. It can also enhance the effectiveness of confidentiality and non-disclosure agreements by linking them to the blockchain and verifying the signing and identity of involved parties. Additionally, smart contract, we talk about them a bit. Technology can be used to document the transfer of trade secrets. Let's talk about, lastly, I did write that one on the presentation, computer programs and softwares. So, okay, YPO is a central figure in global intellectual property law, dedicated to establishing and safeguarding intellectual property rights, IPRs, worldwide. So managing 26 treaties on diverse IP issues, YPO collaborates with countries to ensure uniform standards. Blockchain technology aids in gathering information on IP assets, benefiting entities like the International Searching Authority and the PCT Receiving Office. The copyright laws such as TRIPS and the WIPO Copyright Treaty extend to software covering components in blockchains. In the European Union, electronic programs enjoy copyright protection. However, copyright for software is confined to specific expressions, not general ideas. The both source and object code in computer programs can be copyrighted with a low threshold for originality. But despite shielding blockchain-related software from direct copying, copyright doesn't safeguard functionality or underlying concepts, necessitating alternative protection methods in the blockchain realm. Okay, we can move forward with it. And I think, Batuan, you will be carrying on the presentation for us.
Yes, Asana, thank you.
Thank you.
Hello, everyone, again. Now I will talk about United States and Turkey mainly. In the United States, there are laws that protect people's creations like books or songs. These laws say that once someone makes something and writes it down or records it, they automatically have the right to control who can use it. This is different from other countries that require people to register their creations. It's important for United States to follow these rules so that creators can be protected and their work can be respected. When the United States joined the Berne Convention, which is actually late for United States, they had to change some of their rules about protecting people's creative works. One of these changes was getting rid of the requirement to put a notice on your work to show that it's copyrighted. This made it easier for creators to protect their work, but it also made it harder to prove when they made it. Some people try to prove the date by putting a notice on their work or sending a copy of it to themselves in mail format or something else. However, the people in charge of copyright in the United States say that these methods aren't good enough to really protect your work and be able to take legal action against anyone who copies or misuses it. You have to officially register it with the Copyright Office and get a special certificate regarding that. And blockchain technology can be used to make a new way for inventions, creations, works to be protected. Instead of going to one place to get a patent, for example, inventors would share their ideas on a special record that everyone can see. This would make it easier for the government to handle all the applications and make them faster. It would also make sure that only good inventions get patents, because since there are so many applications, the time they can give to each patent dramatically decreases over the time. And in the future, people from all over the world could use this record to protect their inventions and avoid misusing any protected work or industrial property. There are new ideas that can help USPTO, an organization that handles patents in the United States, to fight against fake patents and make it easier to keep track of when people apply for patents. One of the idea is that blockchain technology, it can make things simpler and save time by reducing the amount of paperwork and tasks that need to be done. On the other hand, Turkey has made rules to protect things like patents, trademarks, copyrights, and designs. These rules follow the same guidelines as other countries around the world. Intellectual property law, IP rights, are one of the most uniform branch of law globally, because almost all countries are signatory to international treaties regarding that matter. The Turkish Patent and Trademark Office, called Turk Patent, is in charge of making sure people follow the rules about owning and protecting their ideas and inventions in Turkey, such as trademarks, patents, and etc. If you want to get a patent or trademark from something you made, you have to ask Turk Patent for registration. But if you make something like a book or movie, which is intellectual property, you automatically own the rights to it without having to ask anyone, without having to register with anyone. Main difference is, one is intellectual property, like things like books or movies, poems, writings, drawings, and other one is industrial property, which is more related to industrial matters. Turkey has not made any special rules for blockchain technology and intellectual property yet. It has its own intellectual property law, but there is no legislation regarding blockchain aspect of intellectual property, like almost in every country. But like many other countries, the Turkish government has been watching closely to see how it develops. In Turkey, using digital money and the technology it's based on is controlled by rules and regulations set by the government. The already established rules are applicable to them. The Banking Regulation and Supervision Agency and the Capital Markets Board try to make sure that everything is done correctly and safely, which can be arguably said that it's going well. Now we can move on, Sabrin, please. And NFTs. NFTs are different from other digital things because they are unique and cannot be copied. NFTs are often made to go along with things like games, artworks, photos, more intellectual, more creative things. Also, we have prepared another paper on NFTs, and Mr. Jem can also share that in the slides if it's available. NFTs can be used to show that something is unique and authentic. They are often used for things like art and inventions, as I said, but they can actually be used for anything. People who make art, or people that come up with new ideas, usually like NFTs, because they help them prove that their work is original. NFTs use blockchain to make sure that the work is real and not a copy. This is important because it helps these people to protect their rights. When someone buys an NFT that relates to art, they're basically getting a special certificate that says they own it. They agree to this by generally clicking or agreeing to some rules on the website or platform they buy it. But having an ownership of NFT means that you have something special that no one else has, because NFTs are unique. But it's like having a toy or game that only you can play. It's unique and special to you. But when it comes to NFTs, the big question is whether the person who buys the NFT actually owns the original thing or just a digital copy. This all depends on the smart contract between the creator and the buyer. Copyright is a whole separate thing from actual object or file that holds the protected work. So there's a distinction between copyright and the work itself. It's important to know this because copyright comes with different rights that can be sold or used on their own. And just to clarify, the object with the work can be sold separately from the copyright. Most people agree that you can sell a physical or digital copy of something without selling copyright. Copyright law assumes that just because you bought a work doesn't mean you automatically own the copyright. So let's say I wrote a book and then I sell it to Asena. Now Asena owns that book, but copyright is still with me. I own the copyright unless it was deliberately licensed or transferred to Asena. This is to protect the rights of the copyright holders and ensure their creative works are well protected. In most cases, the person who made the artwork gets to keep the copyright, but the person who buys the NFT can use and show the artwork, use that artwork for personal use, not commercial use. The smart contract will decide if the NFT is like a license or transfer or nothing else. In a transfer, the original owner gives all or some of the transferable rights to the new owner. But in a license, the original owner lets the new owner use the rights in certain situations. Either way, the original creator still keeps their moral rights, which can't be given away. Our NFTs themselves are work. NFTs aren't really seen as artworks, but more like a way to keep track of who owns a piece that might actually be an artwork. They're basically a fancy contract that use blockchain technology to prove the existence of ownership of digital assets. In the United States and around the world, everyone pretty much agrees that when it comes to law of copyright is its own thing, separate from the actual object or file holding the protected word, as I stated before. That's because copyright comes with a bunch of different rights that can be used or even sold on their own. And it's important to remember that you can sell the thing with the work in it without selling the copyrights along with it. Getting the copyright to the artwork gives you some rights, like able to do copies, sell, and share the work. This is especially useful if you plan on using the artwork for future projects or activities that involve making copies. By having the copyright, you can also have a say in stopping people from making unauthorized copies of both digital and physical art. So when you buy an NFT, you don't automatically get the copyright from the things it's linked to. It's very important. Please be aware of that. The NFT and the thing it's linked to are actually two different things. I'm repeating myself. I know that, but I want you to get it. If you want the copyright, you need a separate written agreement between the owner of the copyright and the person buying the NFT. So you just buying NFT doesn't mean you get the copyright. Also, NFTs can be used for resale rights, resale royalties. NFTs may let artists get a cut of future sales without any hassle. With a built-in system, artists can get a percentage of every sale. No more need for complicated royalty agreements or waiting for payments. It all goes straight to the artist's digital wallet. Basically, NFTs are an easy solution for making sure artists get paid fairly. NFTs and trademarks is one other thing that you should be look at. Trademark law applies to using a mark in a business to show where goods and services come from and set them apart from what other sellers offer. Selling an NFT doesn't mean selling the rights that come with it. Again, it's actually the same. Again, licenses. The person who owns the rights to IP can let others to use it by giving out licenses, and NFTs can be used in that sense. So how can we give licenses, and what kinds of type licenses there are? There are two types of license: exclusive license and a non-exclusive license. With an exclusive license, the licensee gets full access and use of the licensed rights, and the copyright owner can't give those same rights to anyone else. To transfer exclusive rights that have value, a written agreement is is necessary. On the flip side, a non-exclusive license gets the licensee use the rights, but the copyright owner, intellectual property holder, can still give those rights to some other people. And that's it from me. If you have any questions, we would like to address them. Thank you for listening.
It was a detailed and long presentation, so
Yeah.
thanks for the participation. Important topics, so we had to tell a lot of stuff.
Yeah. Thank you very much, Asena and Batuhan. Do you have any questions? Okay, so we recorded the session and we will be having these recordings on our YouTube channel as soon as possible. Thank you for participating and have a nice New Year and Christmas. See you next month.
Thank you, everyone.
Thank you. See you.